All right, friends, it is time to check in with our WSFL trusted advisor, attorney Chad Van Horn of Van Horn Law Group, who's here to discuss judgment creditors and more. Chad, welcome back to the show.
Thanks so much for having me.
Of course. I always learn something incredibly new about how to be better financially when you're on the show, so it's a win-win for everyone. Let's talk about judgments, right? And how a creditor can obtain one, and what are the implications of a judgment?
Well, the first thing I would say is the worst time to fight a judgment is after the judgment's been entered. I have many clients that come to me and they said, I want to fight this. I don't owe it. This is the wrong person. But once that judgment is entered, it's too late to fight, because then you have to look at appellate options and different things, and that gets expensive, and the success rate is really not that great. So if you can get ahead of this, and when you get served with the lawsuit, take advantage of that time to fight it or negotiate at that point. That's the best way to do it. If you do have a judgment entered against you, be very careful, because that judgment gives the creditor rights to take your car, garnish your bank account, garnish your wages. They can depose you. They can get all the information about all of your assets. So it's really a dangerous thing to have a judgment out there and not take care of it.
What are the different types of judgment? I'm sure there's a whole scope.
Yeah, so there's many different judgments that can be entered against you. So usually what people are used to is you fall behind on a credit card and they get a judgment against you for that monetary debt. But there can also be foreclosure judgments against you where they can take your home. There can be judgments where they put liens on your possessions, like your vehicles and different things like that. A judgment and garnishment where they can get a judgment and attach it to your wages or your bank account. So there's many different kinds of judgments out there, but the key to all of them is you really got to get after it and take care of them as soon as you know that it's outstanding.
Being proactive is always key. It seems like judgment creditors have their hands in the myriad of different elements of your life, as you mentioned, but when can a creditor not levy a bank account or garnish wages? What are the different circumstances?
That's a great question. So many people don't realize that there are certain exemptions that you're allowed by law. Most people are familiar with the Homestead exemption, meaning that your homestead is protected from non-voluntary creditors, meaning that if somebody's a judgment creditor, if you get sued by a credit card, they cannot take your homestead in the state of Florida. But also certain income, like Social Security income, retirement income, those are exempt as well. So there's certain things that are exempt. So as soon as you get a garnishment notice, make sure that you see an attorney, because you can exempt out certain assets. If you don't file that exemption, you can waive it, and they can take it anyway.
Who qualifies for those exemptions?
So anybody that's receiving retirement income, Social Security income, if you're head of household, so if you're providing more than 51% support for a minor or for a dependent, you're exempt there. So there's many different people that qualify for exemptions that they usually have no idea, because it comes in this little form that can be confusing. So again, if you ever get a judgment entered against you, take care of it immediately. If you ever get a garnishment, make sure that you get your exemptions in, because you only have 2 weeks to do that. Or again, you can waive your exemptions.
At the core of all of this, Chad, of course, is money, right? That's the running theme of all this. Does it cost to fight these judgments?
So it's actually free if you want to fight it on your own. Generally speaking, if you're working with an attorneys like me and my law firm, we'll work on payment plans. All of our advice is free at first, so we can at least guide you in the right direction. I always tell my clients, money doesn't solve everything, but it certainly solves these money issues. So if you can get together some money, make an offer, and get a settlement on a judgment, that's the best way to do it. If you can't, then you have bankruptcy options and other ways that you can take care of those judgments.
Chad, every time you're on the show, you always hit us with a really cool story. I know you have one for us today. We can't let you go without hearing a Chad Van Horn, WSFL Trusted Advisor story. You always have the good ones.
I do. So actually, I had a couple that came in this week, and they've been together for 30 plus years. And I assumed they were married. They were not. And I was telling them about an exemption called tenancy by the entireties, and how their assets would be exempt if they owned them jointly and they were married. And after 30 years, they decided to get married for that reason, for the tenancy by the entireties exemption. So who would have thought that could bring a couple together to get married?
Chad, playing matchmaker, stranger things have happened, but of course it would happen to you, Chad. WSFL Trusted Advisor, Chad Van Horn of Van Horn Law Group. As I said, every week I learn something new, man. You're keeping my finances and our viewers' finances together. Thank you so much.
Hey, thanks again for having me.